Thank you very much, Mr. Vice Chair. Colleagues, I'm here today to present Senate Bill 747, the No Kings Act. This bill is very straightforward. It ensures that when a federal agent or employee violates the constitutional rights of a person, that person actually has a pathway to recovery, and there is actual accountability for that federal agent or employee. This bill is particularly, we introduced it originally in September, given everything that's happening in the country right now and the activities of not particularly ICE, but other federal agencies who are operating with apparent, or so they think, impunity. And the bill took on added significance last week when Renee Good was shot on the street in Minneapolis last week and killed. It is unclear that ICE agent will, or that officer will face any consequences as a result. Right now, if a federal agent or employee violates the constitutional rights of a person, there is really only one arguably viable pathway to sue, and that is using the Federal Tort Claims Act, which is extremely hard to use, and there are many defenses that the federal government can use to deny any recovery. When a state or local officer violates your constitutional rights, you can sue that officer in federal court under Section 1983, and you can receive damages, and that officer is accountable for state or local, not for federal. There was a doctrine, the Bivens Doctrine, that the Supreme Court created over 50 years ago to allow for lawsuits against federal officers who violate constitutional rights. A few years ago, the Supreme Court gutted that doctrine. So right near today, if a local police officer shoots you with no cause, holds you in a chokehold and suffocates and kills you, violates your right and holds you for no reason and puts you in jail for 5 days for no reason, you can sue and you can be compensated. And that officer has an incentive not to violate your rights because they can be sued. For federal agents, they have no such incentive because they cannot be sued. And that lack of accountability has always been harmful, and it is particularly harmful now with what this federal administration is doing in unleashing essentially secret police onto the streets of American cities to routinely violate the constitutional rights of citizens and non-citizens alike. And so SB 747 will create essentially an identical version of existing federal law, Section 1983, under state law. And so that if a federal, state, or local officer violates your constitutional rights, you will be able to file a lawsuit that is the same as Section 1983. And that those officers will be able to assert all of the defenses that they are currently able to assert to Section 1983 claims. For state and local police officers, and with all respect to some of the opposition, they are already subject to these claims in federal court under Section 1983. This doesn't change the scope of their liability or any of the defenses that they can assert. They are already able to be sued for these violations. This will add federal agents in as well. And so, colleagues, this is, I think, not just a timely bill, but it is long, long overdue, and I hope all 50 states pass a bill like this until Congress actually gets it together to stand up for the Constitution and the rule of law, which it is not doing right now. And I respectfully ask for your aye vote. With me today to testify is George Reddes, a United States citizen, an Iraq combat veteran, a Californian raised in Ventura County, who will tell you about his horrific experience with ICE, and Cameron Kistler, a counsel at Protect Democracy United, a nonprofit with the mission of preventing our democracy from declining into an autocracy. Respectfully ask for your aye vote.
Alrighty, thank you. First witness, please.
Can I start?
Yep.
Yeah. My name is George Redes. I'm a United States citizen and veteran. Before I begin, I want everyone listening to understand this. I did everything right. I complied. I identified myself as a U.S. citizen. I did not resist. I did not impede or assault any agent. What happened to me that day was not a misunderstanding. It was a violation of the Constitution by the very people sworn to uphold it. On July 10th, 2025, I was wrongfully detained during an ICE operation at Glasshouse Farms in Camarillo, California. Despite being a U.S. citizen, clearly stating my citizenship, and fully complying with officers, even though they were all yelling contradictory orders and no one clearly in charge, I was detained and treated as if I had no rights. Agents engulfed my car with tear gas, smashed my window, sprayed pepper spray in my face, and dragged me out. I was choking on gas, unable to breathe, and even though I wasn't resisting, one agent was kneeling on my back and another kneeling on my neck, while my hands were already behind my back. I was first taken to a Navy base where the agents took my DNA. I was then taken to the detention center and held for 3 days without charges. No phone call, no lawyer, no medical care, even though my skin burned from the chemicals. I never even got to shower. I was released with 0 charges and no explanation for anything that had happened. After my release, the harm did not stop. Instead of correcting the record, officials from DHS, specifically DHS spokesperson Tricia McLaughlin, used social media to spread false and misleading statements about me in an attempt to justify my detention and undermine my credibility. I was wrongfully detained and then publicly misrepresented by the very agency that violated my rights. That is not transparency. That is damage control at the expense of the truth. And since they only respond through social media, I would like to ask them to answer these questions, not only to me, but the world. Why I never got a phone call, a shower, or a lawyer, and explain to me and everyone else why I was released without charges if their accusations are true. I've shared these details not to relive the pain, but to make the reality impossible to ignore. I'm not here for sympathy. I am here asking for accountability. Now the responsibility shifts to those with the power to act. It shifts to you and to your decision on whether to vote for SB 747. Justice is not measured by apologies after the fact, but by accountability when rights are violated.
All right.
SB 747 provides this accountability.
Thank you very much. I assume you're urging an aye vote.
All
right, thank you.
What I'm urging.
All right, thank you very much. All right. Next witness, please.
Thank you, Senator Wiener, Chair, and members. My name is Cameron Kistler. I'm a counsel at Protect Democracy United, and I'm here to urge you to vote in support of SB 747. The bill stands for a simple proposition. If any governmental officer violates your clearly established constitutional rights, you should have a remedy. That is already the law for California state and local officials. If they violate clearly established constitutional rights, they can be sued under Federal Section 1983. But there is no similar law for federal officials. The bill solves that problem by allowing Californians to sue any governmental officer, federal, state, or local, that violates their constitutional rights. Because the bill directly borrows its operative language from Federal Section 1983 and incorporates Section 1983's immunities, any constitutional violations that a state or local officer can be sued for under the bill, they can already be sued for under existing federal law. And lawsuits under the bill should remain removable to federal court because the primary legal question posed on the face of the complaint will be whether or not the United States Constitution was violated. I don't think you need to look farther than the killing of Renee Good last week in Minnesota to see why this bill is necessary. I know there's a still debate over what happened, but I think as evidence comes in, one thing is already clear. Whether or not Ms. Good's family should have a remedy should turn on whether or not her constitutional rights were violated, not what badge the officer had when he shot her in the face. Therefore, I ask the committee to support the bill so that no officer is above the law and the Constitution remains the supreme law of the land. Thank you very much.
All right, thank you. Others in support, please approach the microphone.
Mr. Chair and members, Matt Broad here on behalf of Prosecutors Alliance, proud to co-sponsor this bill. We urge your aye vote. Thank you.
George Prampton on behalf of ACLU California Action and support. Thank you.
Chair, members, Noah Bottomo, California Rural Legal Assistance Foundation, in strong support.
All righty. Anyone else in support of SB 747? Seeing no one approach, let's talk to the opposition. If you're opposed to SB 747, please approach the microphone.
Thank you. Good afternoon. David Mustagny, speaking on behalf of PORAC, who remains opposed to 747 in its current form. This bill is unnecessary, duplicative, and it jeopardizes qualified immunity for California employees. There's no reason this bill can't be amended to exclude California employees. First, the bill's redundant. The Tom Bain Act already provides causes of action for constitutional violations that are far broader than 1983 under both the U.S. and the California Constitution, even when the conduct occurs under or outside of color of law. The Bain Act offers stronger tools to address federal overreach in immigration enforcement. The Act provides immunities that apply only to California employees. Therefore, federal officers would be more vulnerable to individual capacity suits. It also doesn't include qualified immunity. Rather, it only requires specific intent, which courts find to be satisfied by reckless behavior or deliberate indifference. There's commonly cases that find liability under the Bain Act for excessive force and unlawful arrest. Second, the Supremacy Clause is still going to present an impediment to enforcement against federal officers, regardless of whether or not this bill passes. And our concern is that California employees will be left holding the bag. Federal officers, the sponsors erroneously claim that the bill is necessary to sue federal officers in their individual capacity, but that's already allowed for under the Bain Act. Moreover, pleading a suit in an individual capacity doesn't automatically defeat the defense of sovereign immunity. It turns on whether the United States is the real party in interest. The Supreme Court has instructed courts to look beyond the complaint's label and determine who is.
Thank you, Mr. Mustagny. My guess is we're going to call you back up for other questions. So, all right. Next witness, please.
Good morning, Chair and Committee. My name is Julio De Leon. I'm a lieutenant with the Riverside Sheriff's Office, and I'm here in opposition. And we echo the concerns of the council that just spoke. But I wanted to speak to you about how it affects law enforcement in California. So during my career, I supervised a team that executed a search warrant on a suspected marijuana grow house. The investigators had probable cause, but one of the indicators was the spike in electricity to the home, which is an indicator of a marijuana grow. The search was conducted lawfully. We detained several residents from the home, and it was later determined that it wasn't a grow house. And the electrical problem was actually with the meter. The meter was reading other homes on that block, so that caused for the spike of electricity. The occupants of the home were members of a protected class, and so there was a claim against the department, and the matter was ultimately settled. However, under existing law, that case was treated as for what it was. It was a good faith mistake on our part for lawful police work with remedies available through existing claims. There was no evidence of threats, intimidation, coercion, abuse, no racial animus. It was just an error. However, SB 747 would change that analysis by creating a new state law of action for federal constitutional claims and removing the coercion requirement that exists under California law and the Bain Act. This bill significantly lowers the threshold for labeling routine law enforcement errors as civil rights violations. Once that label is applied, the consequences go well beyond civil liability. And this is where SB 747 interacts and intersects with SB 2. Allegations of civil violations, regardless of ultimate merit, can trigger internal affairs investigations, Brady disclosures, post-review, and potential decertification by post. Conduct that is currently treated as good faith errors cannot be characterized as civil rights violations. We're told that this bill does not expand liability because it imports the same immunity defenses available in 1983. But in practice, it does expand exposure. It creates an additional state law litigation pathway, authorizes discretionary attorney's fees and expert fees. With that said, we respectfully oppose the bill. Thank you.
Thank you. All right, others in opposition, please approach the microphone.
Good afternoon, Mr. Chair and members. Corey Salzillo, on behalf of the California State Sheriff's Association opposition, also expressing the opposition of the California Police Chiefs Association. Thank you.
Kim Stone, Stone Advocacy, on behalf of the California District Attorneys Association, in respectful opposition. Do appreciate the conversations with the author and the sponsors. Thank you.
Good afternoon, Mr. Chair, members. Ryan Sherman with the Riverside Sheriff's Association, California Narcotic Officers, California Reserve Peace Officers, and the other police officer associations listed in the analysis. All in opposition. Thank you.
Mr. Chair and members, Matthew Seiberling on behalf of the Association for Los Angeles Deputy Sheriffs and the California Peace Officers Association, both opposed. Thank you.
Good afternoon, Mr. Chair. Shane Levine on behalf of the California Statewide Law Enforcement Association, Fraternal Order of Police, Santa Ana POA, Association of Orange County Deputy Sheriffs, and the Sheriff Employee Benefit Association of San Bernardino County, all in opposition. Thank you.
All righty, thank you very much. Okay. Anyone else? Anyone else opposed? Seeing no one else, we'll bring it back to committee. If no one has questions, I have a few questions. Senator Stern, did you want to? Jim, let me just clarify. This is like going back to law school. So let me ask Mr. Mastagni, and I'll ask also the proponents. As I understand the bill, I suppose I'll first direct it to the author. As I understand the bill does not affect in any way the protections and immunities that currently apply to state and local law enforcement. Is that your understanding?
Yes, the bill, in terms of the scope of the liability and the defenses, it is identical to Section 1983. So in that lawsuit about the theoretical grow operation that turned out not to be a grow operation, yes, they can be sued under the Bain Act. They could have been sued, maybe they were, I don't know, under Section 1983, and either liable or not liable, and maybe they would have had immunity. And this would be the same exact liability and the same exact defenses. So for state and local law enforcement officers, they already are subject to the scope of liability with the same defenses as this bill provides. It doesn't change that for them.
So let me ask Mr. Mastagni, is it your understanding that this bill basically does not impact the immunities, qualified or otherwise, and protections that are currently afforded to state and local law enforcement?
In the most recent amendment, that's correct, but my client's concern is that qualified immunity has been on the chopping block for the last 5 years, and in the original version of this very bill, which is essentially the same, this is a little narrower, the original version also covered California law, much like the Bain Act, it eliminated qualified immunity. It was amended back in, but many of the sponsors and the advocates supporting this type of legislation are also some of the most vociferous opponents of qualified immunity. My client's concern is that qualified immunity is saved today, but it's now in jeopardy because currently it's a federal protection. If this law is enacted and local California employees are included in it, then all it takes is a future amendment or elimination of that qualified immunity, and then your California employees, and not just cops, social workers, teachers, any California public employee would be subject to getting sued under essentially a negligence standard without having that protection. Our solution is to just amend California employees out of the bill, or alternatively limit the scope of the bill to immigration enforcement and election interference. We're not opposed to the intent of the bill. We're just concerned about the future and the unintended consequences for your California employees.
Okay, let me try to make sure that I understand it. I have a limited capacity here. So I think what you just told me is that this bill as written today, the bill that we're voting on, does not impact any of the immunities that currently apply to state and local officials. Is that correct?
The current amended version does, that's correct.
Well, we're only going to vote on the amended version. We're not going to go back to an earlier version that's not before us. So the bill that's before us does not impact the immunities, the protections that are currently afforded to state and local officials. Is that right?
That is true.
Okay. But your concern is that somebody's going to introduce a bill later on that eliminates those protections. Is that right?
Absolutely. The qualified immunity is under attack both federally. There was a bill that would have eliminated it a few years ago, and at the state level. And the concern is that we're now doubling the amount of jeopardy by taking what is only available to sue California local and state employees through 1983, putting it in state law, and then the qualified immunity can be removed down the road.
So we should vote no today because someday somebody's going to introduce a bill that will change this bill that will eliminate qualified immunity. Is that, I'm trying to understand your position.
That's the fallback position. Our ask is that you exempt California employees from this bill. The bill is targeted to federal officers. I understand the reasoning behind it. So limit the bill to federal officers or limit it to the subject matters that the bill is intended to address.
Okay. So as policymakers, just to take my assumption for a second, that we want to make sure that Californians are protected from those law enforcement officials that have only 6 weeks training versus the law enforcement officers that are here in this room that have had much more than 6 weeks training. So you take a law enforcement officer with only 6 weeks training, maybe some having none, and we want to protect Californians from those who are vested with federal authority. So what is your suggestion? You say it's unnecessary. If we want to do that, how do we protect Californians?
Well, I say it's unnecessary because I believe that the Bain Act provides a adequate, actually a stronger remedy to bring those claims right now against the federal officers. And then the sovereign immunity issues that I mentioned, they'll either rise or fall on their own, whether this bill is passed or not. My concern is not that. My concern is your local California employees. And so an alternative would be to limit the scope of the law to federal agents or to limit the subject matter of the law to immigration enforcement and election interference.
Let me turn to the author to respond to your suggestion with respect to any limitation. And I suppose I'll ask the author or their witnesses as to current remedies that exist. And I see Officer Riverside, I'm sorry, I'll get your name again in a second, from Riverside Deputy Sheriff's, wishes to respond as well. But let me first turn to the author, then perhaps the author's witness, and then I'm going to respond. Then I'm going to turn to the other primary witness in opposition. So, Sarah Wiener?
I actually have some lived experience here because in a prior life, I, as a deputy city attorney, I litigated on the defense side Section 1983 case claims and Bain Act claims. And I will tell you as a defense lawyer that we were almost, the Bain Act, no offense to the legislature that passed it, it is not a useful law in many respects. It is so hard to prove a claim, and so they would always be tacked on as a adjacent state claim, and but it was 1983. That was how that was where the fight was, and so the idea that we would just use the Bain Act is not helpful, because it is so narrow and limited. And in fact, in the original version of the bill, which we pivoted away from because we heard the concerns, we added federal officers into the Bain Act in the original version that's not before you, and then expanded the Bain Act so that it would actually be helpful. We heard loud and clear the concerns about changing the Bain Act, so we backed away from that and instead did a replica of 1983. In terms of what a future legislature might do to strip out qualified immunity, if this bill didn't exist, someone could introduce a bill in 2 years to do this minus qualified immunity. That's always possible with any law. This doesn't change that. But what this does do is put the legislature on record saying we're going to recognize the federal immunities.
All right. Did you want to have your witness respond, or I'll just ask the Deputy Sheriff, Riverside Deputy Sheriff? Can I get your name again, please?
My witness, I probably should give an opportunity because he's smarter than I am and knows
Okay.
more. So.
All right.
I disagree with that, but I think there were a couple different proposals there. I think proposal one was cover only federal agents. I would point the chair to the recent Supreme Court decision in the United States against Washington. When you regulate only federal agents, you will materially increase litigation risk against the bill. That was a Justice Breyer opinion from a few years back. The other idea I heard was elections or immigrations only. That will also materially increase litigation risk, particularly if it's only in the immigration context. I'll also point out that we live in a time where just this weekend, the chair of the Federal Reserve, who usually just says, I will do something rational in the future related to data, said, the federal law enforcement is being weaponized against me. We are seeing unprecedented First Amendment assaults against media corporations, against law firms, against universities. We need broad protections. We're not supposed to have to pick and choose between the constitutional rights we have as Americans, and I don't think this committee should either.
All right, thank you.
Thank you for the opportunity. My name is Lieutenant Julio De Leon, by the way.
Lieutenant, I'm sorry.
Julio De Leon.
De Leon.
Thank you.
Okay,
I'm also
Lieutenant De
practicing.
Leon, thank you.
I'm also a practicing attorney.
Okay.
So the issue here is not the defenses. That's not the issue. We appreciate the fact that we still have qualified immunity. The issue here is the elements of a claim. The Bain Act provides for intimidation, threats, and coercion. This bill aligns itself with 1983, but it disregards the intimidation, threats, and coercion elements and just makes a plain statement as to a civil rights violation. So the example that I gave, the hypothetical marijuana grow, is that we didn't act with coercion, intimidation, or threats. However, with this new language, the Bain Act no longer applies because those elements are no longer there. So now we, as California law enforcement, are now being dragged into court procedurally to defend. And now we have to go through state court. Yes, we can remove it to federal court, but we still have to go through those steps. And that increases the likelihood of claims against California peace officers. And we have to spend more money to defend that in order to get that qualified immunity removed to federal court.
Okay, I don't quite understand that, but I'm going to send to Senator Wiener.
When we talk, and this is when I talk about the Bain Act, intimidation, threats, coercion. Is shooting someone in the face intimidation, threats, or coercion? You can argue, maybe not. And is putting your knee on someone's neck for 2 minutes intimidation, threats, or coercion? And that's right. If you shoot someone in the face without cause, if you put your knee on their neck and suffocate them without cause as a local police officer, you are right now able to be sued and liable. An ICE agent, not so much. And that is outrageous, and we are not adding anything to the existing liability, and I think that's just been acknowledged. And they keep pivoting back, well, it's different than the Bain Act, but it's not different than 1983, which already applies to them. And so I appreciate that the chair is asking very direct questions, because the answer is very straightforward.
So to Lieutenant De Leon, or Mr. Mastagni, what are you asking that we add additional language to? Now, I'm not talking about basically specifying only federal law enforcement. Add additional language with respect to coercion? Is that what you're saying? I'm trying to understand.
No, I have a slightly different take. Under the case law for the Bain Act, it pretty clearly is coextensive with 1983, with the difference being there's no qualified immunity and you have to show specific intent. So to Senator Wiener's examples, if an officer shot somebody in the face, or I can't remember what all of them were, violated their rights, they would absolutely be liable under the Bain Act. If they would also be liable under 1983. In fact, officers are usually sued under both. And with the definition of specific intent being deliberate indifference or recklessness, or that you intended to violate somebody's constitutional rights, the causes of action against federal officers already exist under the Bain Act. Our alternative position is, if that doesn't satisfy everyone, and can read the room, then keep the California employees, because this is not just about peace officers. This statute applies to every single California public employee, state and local. Keep them out of the bill. They already have the ability to be sued under federal law. Just exempt them. And with all due respect to my colleague, those cases that he's citing, they're really fights about sovereign immunity. And I think even under this bill, there's significant problems with sovereign immunity, but that's not our fight and that's not our concern. Our concern is this bill gets passed for one specific issue to address federal overreach, and nobody is disputing that. It gets knocked out under sovereign immunity, and then it lands on all of your state and local employees, and it's one more avenue to sue, and it's one more jeopardy for qualified immunity.
So, okay, help me out here. So, using your hypothetical, the federal aspects of this statute get thrown out, but the immunities, qualified protections otherwise still remain with respect to state and local officers, right?
So the parade of horribles that we're concerned about,
But let me just ask that question.
Yes,
Do the
for the time
immunities
being,
remain
yes.
intact? Unless somebody comes along next year and decides to do a different bill to eliminate them, right?
correct.
Okay.
It then sets up a situation or a scenario where the intent of the bill is now wiped out by the sovereign immunity defenses, and then California employees can just get sued under purely state causes of action with an equivalent of
They can be
1980.
sued, but they still have the same protections and immunities, right?
They have immunities, yes. The issue about removal to federal court is more up in the air than if you're sued under
I'm going to
1983.
let this rest. So, okay. Thank you, Mr. Mustang.
Thank you.
All right. I've been monopolizing. So let me ask anyone else have questions? Yes. Senator Nielo, then. All right, Senator Reyes. Okay. First, Senator Nielo.
Particularly given the sentiment that has developed against law enforcement in the past 5 years or so, I am very sensitive to the concerns that they have, and I don't blame them for that at all. Additionally, it would seem that actions contemplated by the bill itself would end up in federal court anyway, where state law doesn't apply. So I'm not sure that it ends up accomplishing what you want. But I am very sensitive to what the people are saying relative to local and state law enforcement in California.
State law would apply. So what would happen is if they, whoever gets sued, if let's say someone files an action under just under the, let's say they file it just under SB 747 in Superior Court, whether against a local officer or a federal officer, presumably they will file a petition to remove it, to transfer it to federal court. And because this cause of action is actually narrower than Section 1983. Under Section 1983, you can sue for any violation of a right that's a constitutional right or a statutory right under federal law. 747 is limited only to constitutional rights. So on the face of the complaint, as you heard, it will say U.S. Constitution. It will then, the federal court will have jurisdiction. So it will be a state claim, but it will be adjudicated in federal court. And I want to say that we have, I think, a very solid argument for the constitutionality of this, that this is not subject to federal preemption. There's an explicit exemption in the Federal Tort Claims Act and in, I believe, in the Westfall Act that for adjudication of constitutional claims. And of course, as with any law, they may challenge it, and that's why the courts exist. But we think we have a very reasonable argument that this is a valid exercise of state power. And I don't know if Mr. Chair, I think Mr. Kistler may have had something to add to this discussion.
Say something real fast, which is to say, for most of American history, from the founding to the 1970s, the majority of claims brought against federal officers for their abuse of power were actually state law claims. There's multiple Supreme Court decisions approving that. Teal against Felton, United States against Lee. That's part of the reason why former Solicitor General Seth Waxman said there's strong historical precedence for bills like this.
Questioning? All right, Senator Reyes.
I want to begin by thanking law enforcement for your sacrifices and for the work that you do to serve and to protect us. I also want to turn to George Redis to thank you for your service and to tell you how very sorry I am that as a U.S. citizen, as a veteran, that you were detained in the way that you were detained in such an inhumane way. You are someone who can protect yourself, someone who can defend yourself, who can say the words necessary to say who you are. Yet there are so many others who don't have that ability. Without a doubt, your constitutional rights were violated. And when we're looking at remedies, we have to look beyond just what has been done in the past, because in cases such as yours, what we have available does not work. And as the author has noted, that is the reality today. when you say, I don't want your sympathy, I want to demand responsibility and accountability, and I would join you in that. In everything that we do, there has to be, if there is an action, there has to be a responsibility for our actions. When it's good action, it's the kudos, good job. When it's bad action, then we have to have responsibility, take responsibility for those actions. I appreciate, and for our chair, I really appreciate your questions, because it's so important to clarify what this is and what this isn't, how far this does go, and where we're not doing something that is beyond what is perhaps being described. The concerns of law enforcement may be real. I get it. But I think that where we're living, what we're living through right now, demands action, and the people of the state of California look to us to find better ways, creative ways, sound ways to protect those who live here in California. And 1983 is the way, but it's not going to help us with federal agents who, by all accounts, are arguably violating constitutional rights of people here in California. I appreciate the author's manner in putting this bill together, in taking the necessary amendments to make sure that we are not taking away immunities that already exist for our current law enforcement, and thank you for that.
Thank you. Senator Wahab. Oh, I'm sorry. Okay, Senator Wahab, then Senator Stern, then Senator Ashby, then Senator Durazo. Okay, if I can remember.
Thank you. So I'm a very proud joint author of this bill, and I kind of want to highlight some of the importance of why this is there. First and foremost, we have been seeing what has been harming our nation and the public trust of the people that we hire to keep people safe. And what we are seeing just in the most recent action, within the last week or so, with Ms. Good, a particular officer who not only shot her multiple times in the face, but as the former chair of public safety, who I also understand that law enforcement has an incredibly difficult job. However, seeing so many body cam footage, and in my experience, when there is an officer-involved shooting, most of the officers that I've seen in these videos literally respond with, oh my God, get medics, do this, help the individual, some profanity every now and then, and much more. The video that I saw was 3 shots and walking away and using vulgarity towards the individual that was the victim. No remorse, but almost as if it was intentionally malicious to harm this individual, knowing that they could just get in the car and drive away. That is what happened. That is what we saw. And so bills like this, and yes, we can debate the federal government, we can debate does this law touch them, and we all know the realities. This bill ensures that federal and state officers can be held accountable for their actions by providing the public with an opportunity to reaffirm their constitutional rights. And time again, we have seen people violate other people's rights, people that are more vulnerable than themselves, and be able to walk free. And yes, it is a difficult job, but as policymakers responsible to everyday residents in this country, and in particular this state, when we pay for those government-sanctioned bullets, we have to have a higher standard for the individuals walking around with it. So with that said, I want to thank the author for bringing this forward. I want to thank the individuals who spoke. I also want to thank the opponents of this bill for the conversation. But with that, I will move this bill when appropriate. And again, I just want to thank everybody who's here. Thank you.
All righty, thank you. Senator Stern.
Thank you, Mr. Chair. I just want to follow up on this line of questioning. I think I'll leave the rest of the big picture comments to the others. I frankly think this is a tricky time, and doing politics here and is dangerous for our local and state law enforcement officials who are in essentially an impossible position. So I worry about how, we have to do what we do in terms of this awful federal government, but we also, it's a dangerous moment to be putting them in a bind. And sometimes it's good political theater, but it doesn't actually make them safer on the street or safer doing their job. That's all I'll say as a comment. My question's about the Breyer opinion on U.S. v. Washington you're mentioning. I might have missed it in the analysis, but I was hoping that we could get from the opposition witness just a comment on that. We're sort of seeing it play out with some of the mask legislation now of the targeting specifically of federal officials and how that adds liability. But if that's possible from Mr. Mastagni, sorry to keep calling you up here, but if it pleases the chair and the author, can I just get some feedback about viability of these alternatives? And then the only other question I had on that front was about threats, coercion, and intimidation, and just how that will play out for, say, local or state law enforcement that's, say, doing a peacekeeping exercise. We have raids, and then there's going to be a riot, and then people are going to get killed. It's an impossible situation for, say, my county deputy sheriffs to be in, but they actually do have a role to play, I believe, on the street there to prevent those kind of things, to protect people from, ending up in what is quickly becoming really an escalating violence out there. It's not their own doing, but so, I don't want to see something deter those kinds of peacekeeping efforts during those exercises. But first questions first. Do you disagree with what the proponents said, sort of about the increased scrutiny or liability that it might incur to sort of narrow this? And I don't know if you're familiar with that opinion, but
I do disagree with that. The cases largely cited by the sponsors really deal with sovereign immunity, which is going to be a really big problem. And we've had discussions offline. Their way around it, it's really threading the needle, is to sue federal officers in their individual capacity instead of in their official capacity. That's what I was talking about in my initial statements, and probably was a little bit over your head without the context of those prior discussions. The problem is the case law says if the real party in interest is the United States, you're not really suing them. There's a district court case involving Jackie Spears where she was sued individually for as a lawsuit about telemarketing, and the district court came back and said, no, you're really suing the United States, and you're interfering with a United States function, and the real person who's going to be paying the damages is the United States. Qualified immunity applies. What I believe my colleague was discussing was ways to try to get around that and insulate it as much as possible and be able to argue like, no, this isn't just targeting federal officers, but in fact, it is. It's obvious from the title of this bill that that's what it's doing. And the justification is there's this gap between the coverage of Bivens versus the full 1983 for federal officers. So there's no reason, in my view, why you can't just say we're filling that gap by extending this liability to federal officers, and there's no reason to apply it to state employees if, as the author says, it already exists under the federal 1983.
Right.
And I think there's even a stronger argument about limiting the scope to immigration enforcement and election interference, because there it's applying to everybody, including state employees, but it's just within those subject matters. And we offer both of those as proposed amendments that would insulate your California employees while still accomplishing the author's intention.
So I guess I take your point to be that you don't dispute the fact that the U.S. v. Washington decision that individually targeting the federal government will increase scrutiny, but you're saying the bill already does that by its nature and by its function, and so if there's a more even-handed way to approach this issue, that would sort of reduce that same risk.
That's spot on. The pathway that is intended, and I think this has to just play out in the courts, is to sue officers, federal officers, in their individual capacity to try to get around sovereign immunity. And all of these concerns about narrowing the bill are really concerns about sovereign immunity. And whether or not you can sue an individual, an immigration agent in their individual capacity for enforcing the federal immigration laws and duties and orders is going to be something that the courts have to sort out. We just don't want to get left holding the bag. This bill has a severability clause, which means if it's invalidated as to the feds, then it still remains an additional source of liability for California employees. So I would think at least that should be removed, and if it's deemed to be inoperative to federal agents, then it should just be inoperative altogether.
Can I just ask the author comments on the severability clause question? Just if the intent is really around the federal issue and not so much about increasing liabilities, which you're saying doesn't.
Severability clauses can operate in various ways in various parts of a bill, so that's something we would have to take a closer look at for some hearing about this.
Okay.
I would like to give an opportunity for our witness, Mr. Kistler, if the chair and the senator wouldn't mind to respond to that, because again, as a reminder, it doesn't expand liability.
Right, understood. Mr. Chair, I don't want to over, it's up to you.
I'll defer to Senator Wiener's witness.
Can I make one quick comment on that?
Sure.
Senator Wiener's last comment. I'll remind the chair that you helped us with SB2, and I believe the original amendments to SB2, which was primarily a decertification bill, but also had amendments to the Bain Act, would have eliminated the specific intent and would have raised the identical concern that we have if qualified immunity is removed, and we appreciate that you retain that. And that really, I think, epitomizes our concerns about getting included in this bill where our local and state employees are not the target.
Well, thank you for thinking I remember back 4 years ago. But
I remember.
Right. All right.
Well, I was appreciated nevertheless.
I remember that was an uncomfortable time.
All right. So back. Go ahead.
I'll try and be brief. The intergovernmental immunity, the non-discrimination prong of the intergovernmental immunity analysis from the United States against Washington is distinct from the sovereign immunity question. So the doctrines don't, they're just completely separate things. If you were to exclude state and federal officers, state and local officers, I submit that anyone who read the decision would see the constitutional problems. Sovereign immunity. I think Mr. Mastagni and I both agree that there is no sovereign immunity for individual capacity claims. We both also agree that regardless of how you plead, they'll look behind the face of the complaint to see who the real party in interest is. It's just under every rule I'm aware of, a individual claim for constitutional violation will be an individual capacity claim. Supreme Court talked about the differences. I think the opinion is Lewis v. Clark. It's a 2017 opinion. I would take a look at that. And the last thing I'd say is that the Chang case he cited is a Telephone Protection Act, and it was a couple different subsidiary things. Constitutional claims are different, and they've been different since the United States' Supreme Court's decision in the United States against Lee. There's a whole doctrine called the Larson-Malone Doctrine, I believe, that talks about why there's no sovereign immunity for constitutional claims because officers have no authority to violate the Constitution.
I guess to the question about severability, though, is there a way to tailor the severability clause such that it wouldn't sort of run afoul of this underlying concern that, the federal piece gets knocked out, then you end up with this new cause of action, same standard of liability, of course, but new venue. But, is there a way to tailor severability here so that it still accomplishes your purposes?
So I think you'd still end up in the same venue because you'd remove to federal court if they filed in state court. So you'd end up in the same place. But to take your question, nothing It's a very vanilla severability clause, and generally that's the way to go. I will give it some thought. If I have any good ideas, I will send
Okay.
it on a letter.
Thank you. All I would ask is just going forward, and I'm sure your bill passed today, and I'll be supporting, but I just would urge you to work as closely as you can with state and local law enforcement and the employees here, just to see if there's some really smart lawyering we can do so that we don't just pass a bill and feel good about ourselves and then everything gets knocked out and we spend a bunch of money in court and nothing ever happens, but that we actually make some progress here and, like you said, make a model maybe for the rest of this country to start to follow and take our take the Constitution back. But I would just ask that maybe you give a little more closer look at the severability and then try to study in a little more detail that issue, that idea of a sort of across the board on election interference and I forget the other piece. And on immigration, so that it was sort of a more uniform standard that wasn't just targeting federal officials, but that we sort of had, just a different way of slicing it.
Yeah. So what I will say, obviously I can't commit because we will look at the severability issue to see if there is something that makes sense and is not undermining and harming what we're trying to do, which is to protect people's constitutional rights. In terms of limiting subject matter, I think as articulated before, and I agree, I think that is not something that I would be open to limiting the kinds of constitutional rights. It's that's not. I think that's a very problematic path to go down. And we also see, given the breadth of constitutional rights that are being violated right now, which are not, obviously shooting someone in the face or holding someone for 3 days for no reason is like, we see that a lot, but it goes way beyond that. Last thing I just want to say is, I understand, I want to be very clear, this bill is not just about being performative. That's not what this bill is. We are really trying to deal with a very, very real issue that you have federal agents who truly believe that they can do anything and not have any consequence whatsoever. And what Senator Wahab mentioned is absolutely true, because I have watched many videos and recordings of officer-involved shootings, and I know that for those officers, that is a life-changing situation when you shoot someone. And you can hear it in their voice, whatever happened, whether it was right or whether it was wrong. That is a life-altering situation for that police officer, and for, of course, for the person shot and for their family and everyone else. And the callousness that we are seeing here, not in every case, right? I'm not going to broad brush, but all too often, and this feeling of impunity as egged on by the President and Vice President of the United States and the Secretary of Homeland Security, who are basically telling them, don't worry about it. You can do whatever you want to those people because of the language they're speaking or because of the color of their skin. Just do whatever you want because of their political party. And that is what we're trying to get at here. And we think we do have the power. Can never predict how a court's going to rule, of course. But we think we do have the power to do this. And in this day and age, we need to, find the ability, whatever ability we have as a state to protect our residents. I think we should do it, even if we know that there will be a challenge and the courts will adjudicate it.
I completely agree with that. My caution for you is that if we put state and local law enforcement in a position where they're frozen, where they have to sort of sit on the sidelines while this plays out, and they don't feel that they can step in to keep the peace during these moments, that things are going to get so ramped up that you can't walk back. So I agree that we can't play out the court. I'm just trying to sort of get a sense of on the ground how to maintain a legal framework such that our people feel as safe as they possibly can to call the police if they're abused in their home, and that even if you're an immigrant, you can still feel safe to call the police, and that we're not going to start getting people predating on immigrant families and their communities. It's just it's a tricky problem. I applaud you for diving in here. There's no easy answer. It's an awful situation to be in. It's just
and I appreciate all of that, and I really do appreciate that. I have someone, even though I had some tension between this bill and the masking bill with law enforcement, I have for decades worked with the San Francisco Police Department. I have very close relationships there. I have worked with them when I was a deputy city attorney, I have enormous respect for the hard work that law enforcement does, for which, as the chair pointed out, they are intensively trained. I go to the police academy graduations whenever I can in San Francisco, and I'm very proud of these young people for entering and they are intending for it to be an incredibly noble profession, and they are putting their lives on the line for the community, and they want to serve. And what is happening now with the feds is making their lives so much more difficult and actually absolutely putting them into a corner. It is horrible for them. And I think that when we have real accountability for the federal agents, that is going to make things better for state and local law enforcement, in my opinion.
All right, so we're going to incorporate those two answers.
I respectfully ask for an aye vote.
Oh, no. We got Senator Ashby, Senator Rosso, and Senator Caballero, and Senator Valadares, and Senator Weber Pearson. Okay. Let me make a couple comments here, and maybe that will allay some fears. And I recognize that my questioning was rather pointed. But what Mr. Mastagni has raised and what Lieutenant De Leon has raised are significant issues. And we've had this bill in print for a week. It blew up in the last 48 hours in the sense that people became seriously engaged. I've heard what you've said about providing an amendment to exempt out or exempt in or specify as to its specific provisions. I think that this is not the final committee it will go to. And I would urge, and I think Senator Wiener is amenable to this, to continue to work on it, how we can make it as targeted as possible, how we can protect Californians from those who, in my view, have inadequate training, and we are basically creating a system, if there are no consequences, where we both encourage and enable inadequate training so that we can be more precise. So the point is we have heard you, and we will continue to work. But now, turning to Senator Ashby, Senator Rosso, Senator Caballero, and Senator Valadares. All right, Senator Ashby.
And then Weber.
And then Senator Weber Pearson. Right.
Okay, well, first of all, thank you to the author for bringing the bill forward and also for using your extensive background both in civil rights and in representation of the San Francisco Police Department as a former deputy city attorney to bear on this law. I'd also just like to personally thank Mr. Mastagni. I've had the opportunity to work with him for many, many years and know him to be extremely reputable and very good at this kind of work, and we couldn't be asking for a better partner to work our way through this than the ones that we have in front of us, at least so far as I can tell. Thank you to the lead witness on the proponent side for sharing your story with us. At the end of the day, I'm sure you figured this out now after sitting in the Judiciary Committee, ever popular, for long enough that everyone in this room, everyone, including the people who got up and testified against this bill, want to protect you. This is just an argument about the legality of the best way to do that and to make sure that what happened to you doesn't happen in California without consequences. I think everyone in this room would agree to that. I know Mr. Mastagni well enough to say on his behalf, I know he agrees with that. We want to protect young people and all people in California. You sharing your story is so poignant and important because it helps us focus in on that and not get lost in the weeds of all of our law degrees that are up here. Though our professors would be very proud of us for even trying to remember, rules of procedure and whatnot. Anyway, so I want to stay focused on that because what happened to you is not right. The good counselor, and Senator Reyes, she expressed that, and I think on behalf of all of us, we would all agree with her words. So I hope you'll take that home with you in your heart, that every word that came out of her mouth I would associate myself with, and I'm sure most of my colleagues would too. That being said, we need to legally get this right, because we can't have social workers or teachers or something with some loss of a defense or loss of immunity privilege because we lost in court and we weren't careful and we didn't get the severability claim right, or we somehow, messed up qualified immunity or sovereign immunity here. I don't think we're going to do that. You have an extraordinary author who will work all the way to the end on this and make sure that it is as solid as it can be to withstand a federal challenge. Seems like he has solid assistance as well. So I have every faith in the author to get this where it's going to go. So I do plan on supporting the bill today, but I want to speak because I want to share with you some of my concerns because there will be additional votes. And I'm hoping that some of these things are addressed. I know you'll work on it. I've never even seen you start a bill without working really hard all the way to the finish on the pieces. And I agree wholeheartedly with what you are trying to achieve here. And I think you're well on your way. For me, I would just say to Mr. Mastagni, it's not particularly persuasive, and I think you heard this from the chair, to make an argument about future legislatures removing qualified immunity. I understand why you're doing that, and I understand the argument that you're making, but it would be very difficult for us to legislate in that manner, that we would worry about what a future legislature would do. Almost anything that we do up here can be done or undone or modified in the future. But to that end, because you are concerned about it, and because I think I understand and want to honor why you're concerned about that, and I understand that to be that you don't want government employees of the state of California to somehow lose a defense that they have. In the bill, there is actual language, which I'm sure you saw in the last week that you had to review it. There is specific language that holds neutral both qualified and sovereign immunity, but in the analysis, the language is a bit stronger. So if you have a chance to look at that, the analysis actually says that the bill preserves the defense of absolute or qualified immunity and reiterates that position for sovereign immunity. So I understand that that's analysis and not in the bill. I get it, but analysis can be helpful when moving forward, and that might be something that you might want to keep with you. I think at the end of the day, in California, we're extremely frustrated with our inability to protect folks from basically an agency that's federal that proclaims to be law enforcement and yet is unrecognizable to our eyes as law enforcement. I served on the Sacramento City Council for 12 years. Mr. Mastagni worked with me on passing laws there that I have seen ICE just completely ignore. They're allowed to ignore the Constitution. They don't need probable cause. They're clearly that you can't shoot into a moving car away from you in this state. We don't allow that. We've passed all those bills. So how can we find some, mechanism of recognizability to the law enforcement component that the feds say they're sending here for a level of enforcement we don't even want. Now, obviously, we've all issued these statements that we don't want that. We don't think that's right. It's terrible. And we're watching people all across the nation have to fight this issue. So what legal protections can we put in place? And I think that's what this bill is seeking to do. And it's hard because we're going to run right up against the line of what is allowable. I think that Senator Stern's line of questioning in this, Senator Wiener, I just want to associate myself with his comments because I do think, obviously, a severability clause, we often use that in our language, but perhaps it could be tailored a bit more in this bill to the extent that if somehow we did run afoul, that it wouldn't suddenly only apply to state employees here, without its intended application, which is much broader. Perhaps some folks smarter than I can help you broaden that language or narrow that language more specifically to protect the outcome you're trying to achieve. I deeply appreciate the fact that you've clearly mirrored 1983 here so as to be careful, and that I would agree with you that the Bain Act is ridiculously hard. Coming from a city standpoint, the implementation of that is ridiculously hard, even in today's environment, much less if you are trying to apply it more broadly on a federal level. So from my standpoint, I'm going to support this today. I think it's really important that this conversation between the opposition and the author and his proponents continues. I'm hoping that this is not the final version of this bill. I think that there's more work to be done, but it's on track to do something really critically important that we need to do. Just please, I think I reiterate the comments of several other members up here that I look forward to seeing the future drafts and how these brilliant minds in this room, you have some incredible lawyers, yourself included, who are working on this, advance it to a position that it is defensible but also implementable.
Senator Ashby, Senator Durasso.
Thank you. Someone mentioned the sensitivity that they're looking through, the lens of sensitivity on this. The lens that I'm looking at this in the broad policy way is that our communities are facing extreme violence. And that's going on every single day. Some version of that existed before, but it's just remarkable. It's just mind-boggling to see the kind of violence that's taking place in our communities every day by federal agents. So that's the lens that I'm looking at, and I consider the issues that have been raised by the opposition important. But I want to distinguish between those who are allowed right now, encouraged to act the way that they're acting, and separate them and distinguish them from the federal agents. It is really, really, we worked very hard over the years in our communities to have a relationship, a positive relationship with law enforcement. We worked really, really hard, especially when it came to the immigration issues. And now all of that is really getting hurt and damaged and destroyed. So I invite the opposition to keep working at this if you believe that you would be hurt. But please help us get to the bottom of having another tool to stop the outrageous, inhumane treatment that is taking place every single day. Thank you.
Alrighty. Thank you, Senator Durasso. Senator Caballero.
Thank you very much, Mr. Chair. The thing about going last is that everything seems to have been said.
You're not last. Don't worry. So,
I know. Well, close to the end.
Right.
Let me just thank everybody for their testimony. Really important discussion and really good questions and have been asked. I think the challenge from my perspective is that there's a level of lawlessness that that makes it difficult, because if we want to act in a peaceful way, it's hard. I'm impressed, Mr. Redes, that you were able to act in a peaceful way, because on purpose I am not carrying my birth certificate or my my documents to indicate I'm a U.S. citizen. I am entitled to walk free unless there's probable cause to believe that I'm doing something that I shouldn't be doing. And if you want an answer from me, you're not going to get it. Leave me alone unless you've got some facts upon which you can make that conclusion. And I recognize it puts me at risk. And I also recognize it'd be pretty darn hard for me to not resist and struggle if someone decides they're going to try to lay hands on me. And the real issue is that we have untrained individuals that have been hired that have been given a bounty to use rubber bullets and tear gas and military equipment that they're unprepared to use with no restrictions at all. And I want to thank the author for jumping into this area. It's we have to protect people, and that's what we ask the sheriffs and the police officers to do, is to protect people. And they're in a really awkward situation because they're out there looking at people that are masked and refusing to show identification and act under color of law that they refuse to back up with paperwork or with badges. So I want them to be protected as well. And I think there's more work to do on this. I'm going to support it today. I think it's really important to move this forward. And I think we have to send a message to the community that we're doing everything we can to defend them and to make sure that people feel like they're still a part of the community and they can make police reports and they can feel safe, and that yeah, I mean, I think that's from my perspective, is that I'm just angry because if we're good citizens and understands history, this is not the first time this has happened in this country, and so we've got to do everything we can to lay the rules in place to protect our citizens and make sure that it doesn't move any further. Thank you, Mr. Chair.
All right, thank you, Senator Caballero. Senator Valladares.
Thank you, Mr. Chair. My father-in-law, who is Guatemalan American, was a near 4-decade LAPD officer. He was shot in the line of duty. One of my best friends of nearly 25 years is now an LAPD detective, a mom of 3. My uncle, a former federal agent. My other best friend, the wife of an LA deputy sheriff who serves in the local jail. My district is home to thousands of federal agents, of law enforcement officers, of first responders. So the impact of this bill is deeply personal to me. And no one is saying that accountability doesn't matter. But accountability only works if it's fair, if it's predictable and grounded in the rule of law. If an officer already faces liability in federal court for violating constitutional rights, what does creating a second overlapping state system actually add other than more litigation? If our goal is better policing, how does retroactive liability going back to March 1st help officers who were trained and acting under the law as it existed at that time? Would any of us accept being judged tomorrow by rules written today? If we truly believe in fairness, in due process, why are we encouraging lawsuits by stacking attorney fees, cost, and expert fees, knowing full well that even weak cases become too expensive for cities and counties to fight? And when that happens, who pays for it? Not Washington, not Sacramento. Our local communities pay for it. Local police departments pay for it through fewer officers, less training, and reduced presence on the streets. If qualified immunity exists to protect good faith officers making split-second decisions, then why are we creating new pathways that repeatedly test those protections in state court? At a time when recruitment is already a challenge for every department, and you hear this in your districts. Morale is low, and communities are asking for more visible law enforcement, not less. What message does this send to the officer who shows up every single day in good faith? So if this bill creates a new state cause of action that mirrors civil rights lawsuits, adds new financial incentives to sue, applies retroactively to conduct that was lawful at the time, and increases pressure on cities and counties to settle even weak cases, then how is that not an expansion of liability for officers? It is.
It's not.
Protecting civil rights and supporting law enforcement are not opposing values. But this bill forces a false choice. And the people who are going to feel it first are in the communities that we all represent. It's probably more of comments but there's a few questions in there because I've heard repeatedly that this doesn't expand liability. Everything in the language to me says it does.
Is that a question, or?
Did you want to respond, or you want to wait till your close, or how would you like to handle this, Senator?
Whatever you prefer, Mr. Chair.
I prefer close.
Okay.
Okay.
There we go.
Is that okay with you? All right. Okay. Thank you. All right.
Thank you, Chair. I think, you know, when you read the bill and you look at sections D and E, it really kind of lays out some of the concerns that was just mentioned by our senator and some of the opposition, that it would not extend anything for our local police officers and those who serve in local law enforcement. So I know you'll talk about it in the close, but it's kind of in the bill. I want to just really start by thanking you for being courageous to bring this bill forward. We are in unprecedented times, and you know, I am saddened by the fact that we even need a bill like this. But when we see the things on TV and we hear the stories from like our witness, and I apologize. No one, oh my goodness, should be treated like that. Whether you are here legally or not, and I know you are, but everyone deserves basic human rights, and you were not treated in that manner. And so I apologize, because you will not receive an apology from those who did it. The only thing that I want to say and potentially caution you, I know there's going to be a lot of pressure for you to really focus and narrow the bill and become very, very specific. And I think the issue with that is we don't know what is to come. A year ago, we would have never thought that we were saying the things that we're saying now. I mean, we believe in our Constitution. We believe in law and order, and what we have seen is the complete opposite of that. And I don't want us to have to continue to be in a reactive mode. So I just hope that you don't whittle it down too much. I know you, but I'm just saying on the record, I know. That we look up and we say, oh my goodness, now this is what's happening to our residents in California or residents in Nevada or Ohio, and we have to respond to something that we could have addressed or that we are addressing in this bill. So thank you for your courage. I know it is not easy. I don't know if anyone has moved the bill, but if not, I will definitely move it.
All right. It's been moved by, did anybody else move it? Oh, Senator Wahab. Beat you to the punch. All right. Senator Wahab has moved the bill. I think we've completed comments and questions. Senator Wiener, would you like to close?
Thank you. And to Senator Weber Pearson, you have my assurance. As I've indicated, this is not just about one constitutional right. It's about everything. For example, Brendan Carr, the chair of the FTC, is like a walking constitutional violation. If there were First Amendment prison, he would probably have a lifetime sentence because of the just extreme First Amendment abuse that they're trying to inflict on members of the media. So this is not only about ICE. This is about constitutional violations. I appreciate Senator Valadares's remarks, and I too have law enforcement officers who live in my community, and I know a lot of them. It's expensive in San Francisco, so I wish we had more, but we do have plenty, and they are our neighbors. But I want to just correct the record, because this does not change the rules or the liability for those officers. This is creating the ability to file a lawsuit. This does not change what those constitutional obligations are, in addition to the fact that if a local police officer committed a constitutional violation in March or April or May of last year, they were already potentially liable under Section 1983. This doesn't change that. And if they do something in March of 2025 And then in May of 2025, the courts announced a brand new doctrine. So what they did was legal when they did it and then illegal later. That's qualified immunity. That's classic qualified immunity. So this is not about changing the rules. It doesn't, because it doesn't. This doesn't. I wish we could amend the Constitution by California statute. We can't, so the rules will not change. So colleagues, I really appreciate the thoughtful discussion. We, of course, I always have an open door for folks who support or oppose or anything else on a bill. Well, of course, we want to get it right. We want to make sure things are drafted correctly. But this is an important bill. It is important that people have the ability to hold folks accountable when they violate their constitutional rights, often in severe ways. And I respectfully ask for an aye vote. Oh, and if I could just say one more thing, I want to thank Mr. Redis for coming out. And this is true, happens in this legislative setting, that we have people who have gone through intense trauma, who have had things happen to them that none of us, hopefully, have ever had to experience. And I'm always just so grateful to anyone who's willing to take something horrible that happened to them that is difficult to talk about and to go public and talk public and be uncomfortable in order to make change so it doesn't happen to anyone else. So thank you for doing that. I ask for an aye vote.
All righty. Committee Assistant Porter, please call the roll.
This is file item number 7, SB 747. The motion is due pass to the Senate Appropriations Committee. Umberg?
Aye.
Umberg, aye. Nilo? No. Nilo, no. Allen? Ashby? Caballero? Caballero, aye. Durazo? Durazo, aye. Laird? Laird, aye. Reyes? Reyes, aye. Stern? Stern, aye. Valadares? No. Valadares, no. Wahab? Weber Pearson? Weber Pearson, aye. Wiener?
Aye.
Wiener, aye. 8-2.
8-2. We're going to put that on call. All right. Thank you.
Thank you, colleagues.
I think I am next.